Good evening, everyone. Welcome to another SFL webinar. I'm Nick Roskams, and tonight we are welcoming Professor Stephen Davies, who will be talking about the private provision of law enforcement from a historical perspective, as you can see on your screens. But before I start, let me give some information on ESFL, on European Students for Liberty. Most of you will already know us, but just for those of you who have not had the chance of attending one of our events, ESFL is a student-run organization run by students and for students that attempts to help the European Students for Liberty movement throughout our continent. We do this by providing resources, by organizing networking events, by offering leadership training, by these webinars, of course. We also offer free books. And of course, we are organizing our regional conferences at this moment, which I hope some of you have attended already. If you want more information about us, then you can always find it online on our Facebook page or on our Twitter account. We're all over the place, so feel free to check us out or ask us any questions you might have about us. For tonight, as we've said, we have Professor Stephen Davies, who is the Education Director at the IEA, and he has agreed to speak on the subject of his thesis, if I'm not mistaken, private law provision. So without further ado, I will give him the floor.
Thanks very much, Nick. And this is indeed a subject I've got a long-standing interest in, so I'm delighted to have this opportunity to take part in this webinar and do something to help European Students for Liberty, an organisation that I strongly support, and I urge anyone listening to support it as well if you don't do so already. So the starting point really for this is that most people today have a number of assumptions about law and the state. If you ask most people what the state is today, they will typically quote you the definition that Max Weber gave in Politics as a Vocation, where he said that the state is that institution that has a monopoly on the legitimate use of force within a given territory. And the provision of justice of a legal system, police force, courts, things of that sort, is typically seen as being a part of that monopoly on the use of legitimate violence. Now, the assumption, therefore, is that, first of all law is state law, that it's only the state that enforces law and makes law. This is actually not true even today, but it's still widely held to be the case. The other assumption, which is even less questioned, including by many people who would question the first, is that there are two quite distinct and different kinds of law. The first is civil law, the second is criminal. In fact, historically, as we'll see, neither of these has been true. Now, in the 5th and 6th centuries, the Roman state collapses in the western parts of the empire. It isn't exactly overthrown, it rather just collapses under its own weight, because essentially the burden of taxation becomes too great for the populations of the western provinces when given the amount of benefits that they're getting from the state they're supporting. And once the state has collapsed, power passes into the hands of German tribes who had settled in many of the provinces of the Roman Empire. Many of these, by the way, by invitation. By the time you get to the 4th or 5th centuries, the bulk of the Roman army, for example, is made up of Germans who have been hired by the Romans to fight in the military. And that's one of the reasons why power passes into their hands, because in most of the provinces, such as Gaul, and large parts of Italy, the military commanders are in fact leaders of Germanic tribes. But although they in some sense inherit the political power of the now collapsed Roman state, these Germanic leaders were not able to sustain the elaborate state system that the Romans had built up. And this included the law. And so the Roman law, which had been a living and vital thing, obviously under the emperors, passed into history and existed for many years only in the shape of the text of the Roman codices and compilations of law, which were in fact, for forgotten in the West for quite a few hundreds of years before they were rediscovered. Now, as I say, we take these two things for granted, but neither of these principles was true at all during the so-called Dark Ages, the several hundred years that followed the fall of Rome, roughly between the 6th century and 12th. During this period instead, what you had was a unitary legal system. In other words, throughout this period, in the whole of what is now Western Europe, the old parts of the Roman Empire plus Germany and Central Europe, you had a unitary legal system which made no distinction between civil wrongs and criminal wrongs. They were all treated, with one very small and significant set of exceptions, in the same way. Now, the legal system that you did have at this time is often described as primitive, but that's actually very misleading, because the term primitive in English these days implies crude, undeveloped, and simple. And none of these is an accurate description of the legal system that we had at that time. In fact, it was highly sophisticated and subtle, and also very effective, but radically different from what we think of as a criminal legal system today, or any kind of legal system today. Now, the great goal of the legal system that was brought into being in the aftermath of the fall of the Roman state was to minimize social conflict and violence. This was a vitally important concern at the time, because this was indeed a very violent society in many ways. It was a society where every adult male typically carried weapons as a matter of course, particularly if you were a free man, but even slaves would carry a pretty sharp knife with them most of the time. And we know from the graveyards and the other kind of records that we have that this was indeed a society where interpersonal violence occurred at quite a high level. So the great goal was to try and minimize this, and above all, to stop it spreading. The thing you wanted to avoid at any cost was to have disputes between people over mundane matters being settled by resort to violence, because of the danger that this would lead to larger scale social conflict. Now, the legal system handled this fundamental problem, which is one that we still face today. It's the underlying problem that all legal systems are there to deal with. It dealt with it by sophisticated use of incentives and by the use of private action rather than action by states or their then equivalents, kings and rulers. Now, the default situation was the blood feud. If you injured somebody, in particular you killed them, but even if you injured them in a lesser way, you were in dispute not only with the person you've injured, but with all of their relatives, their kin. And that meant, for example, if I killed my neighbour, the dead man's family will have a duty and obligation upon them to come after me and kill me in turn, which then in turn means that my family now have a blood debt to pay against other ones. As you can imagine, blood feuds could often lead to an awful lot of dead people and mayhem. Now, you might think this is actually a rather strange and barbarous institution. In fact, the whole point of the blood feud was to minimize violence, and it did this by raising the cost of it. You're going to be much less likely to use violence against another person if you know that by doing so, you bring down upon your head the vengeance of all of their living kinsfolk. And of course, your own family are well aware of this, and so if you are a hot-headed person with a predisposition to violence, then they're going to try and control you, because they have no more desire to be involved in a blood feud than any other sensible person. So the blood feud is the default way of dealing with violence, and the way it works is by raising the cost of violence. However, of course, occasionally the system doesn't work, and you do then get very bloody feuds. These are often the subjects of famous sagas or poems or stories and narratives. The reason why they are remembered in this way, however, is precisely because blood feuds are actually rare. Although it was the default system, it was something that was hardly ever triggered, because the whole system was designed to avoid doing this and to find other ways of settling disputes. And the way this was done was by treating most harms in the same way. If you harmed somebody, and this would be true whether you damaged their property, whether you stole their property, whether you injured them, whether you assaulted them, whether you killed somebody, the normal result was if you were found responsible for this harmful act, you had to pay compensation to the person you had injured or to their family. And this was typically done on a scale. There was a well-known and well-established scale of compensation that had to be paid. In Anglo-Saxon, this was known as the wergild, the man price, or man gold, literally. Where is man in Saxon? Gild means gold or money. More generally, the compensation is known in most of the German languages as Bort, or boot, B-O circumflex T, if you want the exact spelling. Now, how does this go about? Well, the fact is that there is no state structure of courts, nor are there state law enforcement officers. Instead, if you are the victim of a crime, what you do is to appeal to the local community, who will then call the person, summon them to appear before a local court, known as a moot in England, slightly different names in the other parts of Europe. The court is literally just an area of land that is fenced off. When you're summoned, they literally call you by shouting your name out and broadcasting. And once you step over the rope into the fenced-off area, you have indicated by doing this that you will decide you will abide by the decision that the court makes. The court is simply made up of the people in the community who know both parties to the dispute. There isn't a hierarchy of courts, although there are some courts which appear to be higher than others. It's just that they deal with a larger geographical area. They're all courts of first instance. There's no straightforward appeal system or hierarchical system of the kind that we're familiar with now. So suppose I have injured somebody, that person will then bring a case against me before the local community court. He or she will charge me before the court, and I then have to appear and explain what has happened and tell my side of the story. The court will then decide who is in the wrong and who therefore is owed compensation and how much compensation should be paid. They will do this by drawing upon their own experience, but also upon what you might call the folk memory, the memory that the older members of the community will have of how things like this and how matters of this kind have been dealt with either earlier in the same community or in neighbouring communities at some stage or other. And so gradually over time a body of general rules is drawn up or appears and emerges which tend to determine how you decide particular cases. But when a specific case comes up, of course, the local court have it within their power to decide to vary this or to bring in some novel way of dealing with it to take account of peculiar or particular circumstances. Now you might ask, well, what about kings? Because of course there are kings all over Western Europe at this time. They do have an important role, but it's limited. It's important to understand what it is. The first is that they are the ultimate arbiters. So if you have disputes between people who are particularly powerful or important, then very often it's just the king who will settle the dispute, who will act as the arbiter, who will decide who's in the right or who's in the wrong in that particular case. There's an obvious reason for this, it's to prevent political disorder. Even more importantly, what kings do is to provide guides to the compensation. What they do is to promulgate what are called law codes, and there are many, many of these. The Lex Gundebadorum, for example, the Burgundian law code, the Lex Salica, the law code of the Salian Franks, the Lex Langobardorum, the law code of the Lombards, and several codes issued by the Visigothic kings in Spain, many, many codes issued by Saxon rulers in the British Isles. These law codes are not, however, legislation in the way that later enactments or statutes issued by medieval rulers would be, much less the kind of laws made by a modern legislature. What the kings are doing, essentially, is providing definitive guidance to local communities as to what the scale of compensation should be for different kinds of injury. That's why if you read these law codes, they are typically nothing but enormously long lists of the precise amounts of money that needed to be paid in compensation for various kinds of injury. So much for an ear, so much for a thumb, so much for an eye, so much for cutting off a hand, so much for theft, and the like. There are a number of other important institutions that it's worth drawing one's attention to in this system. The first of these is outlawry. This is a way of dealing with the people who simply refuse to go along with the system. Stubborn, hard-hearted and hard-headed people who refuse to appear in court or who seek to evade the claims of justice. If you do this persistently, then you are declared to be an outlaw. What that means is that you are publicly declared to be outside the protection of the law. From that point on, anyone can kill you or do anything to you with no fear of redress, because you are quite literally outside the law. An outlaw's life, unlike the legends, is not a happy one. You do not spend your time living in the greenwood, wearing green tights and eating lots of juicy steak from deer that you've killed. You in fact lead a miserable and short life, and it's much more like being the main character in the Arnold Schwarzenegger movie, The Running Man. Your chances of surviving are slim, to put it mildly. In fact, the usual course of action for people who are made outlaws is to leave the society entirely, and typically what people do is go all the way over to Byzantium and join the emperor's guards, the Varangians. You're effectively out of society. That's the only way you can survive. So this is a very powerful sanction, and it provides extremely strong incentives for people to comply with the law and to take part in this voluntarist, bottom-up system for the resolving of disputes, as I've described. Another important institution is compurgation. This is used in cases where the accused person denies the truth of the accusation. What you do in such a case is to swear an oath. Both the accuser and the accused would have to swear an oath as to the truth of what they had said. You have to realize that that was an enormously significant thing to do, because all of the inhabitants of Europe at this time, whether pagan or Christian, thought that swearing a false oath was about the worst thing that you could possibly do. It would certainly bring you a terrible punishment in the afterlife. Even more importantly, in the immediate present, however, it meant that if people thought you had sworn falsely, nobody would ever have any kind of dealings with you again. You would be a complete social outcast. Now, compurgation meant that you got people to swear that your oath was true, so-called oath helpers. What this was actually a quite sophisticated way of establishing your good credit and good name. If you had a good reputation, people would feel safe in supporting your oath and swearing an oath themselves as to your truthfulness. If, on the other hand, you were regarded as a dubious character and your veracity was in question, then people would have grave doubts about your truth of your testimony, and they'd be much less willing to support your oath. So compurgation, oath helping, was actually quite a sophisticated way of establishing the relative trustworthiness, reliability, and good faith of the parties to a dispute. Finally, there was the ritual of ordeal. This was done in a number of ways, and it was the way that was used to finally establish the guilt or innocence of people in extremely difficult cases. The two best known ordeals were the ordeal of hot iron and hot water. In the ordeal of hot iron, you would pick up an iron bar which had been left on a brazier full of coals while a priest said a prayer. You would then carry the hot iron bar for a certain number of steps, after which your hand would be bound up. After 3 days, the bandage would be taken off, and if your hand was starting to heal, then you were innocent. If your hand was starting to fester and suppurate, you were guilty. It was an appeal ultimately to God to decide who was true and who was not. When you look at the records, what you discover is that almost invariably people were acquitted when the ordeal was resorted to. And also, from what we can tell in almost every case where we have access to other information, the ordeal almost always got it right. It almost always was the correct verdict that was arrived at by the ordeal. This may seem strange, but Peter Leeson, George Mason He has written a quite brilliant paper pointing out the reasons why this was the case. So long as people believed that there actually was a God who would act through the ordeal, the only people with an incentive to use it were those who were in fact innocent. And therefore it's not surprising that the thing tended to result in an acquittal, not least because a crucial participant in the ordeal was the priest, and he would always take confession from the accused person before he administered the ordeal. The priest typically then could manipulate the whole procedure in such a way as to increase or decrease the likelihood of the person suffering really severe burns. Hot water, by the way, involved shoving your hand into a pan of boiling water to pick out a stone, with the same basic principle that you had to see if you were healing after 3 days. The real social function of the ordeal was to provide a definitive resolution to disputes where both sides were completely intransigent. It was a way of providing a verdict which nobody could argue with, because it was an appeal to divine authority, not human. And so what it did was provide yet another way of preventing social conflict from appearing. So what we have here is a system which has an enormously complex and sophisticated system of incentives and penalties which encourage people to behave in an orderly way, and if they behave in a disorderly way, to accept monetary compensation for their injuries rather than resort to armed force and vengeance. So it was a very important way of making society as orderly as it could be given other considerations. The whole thing had only a minimal role for what we might call state power, and was driven almost entirely by private action on the part of injured parties and also on the part of the people who collectively formed the courts that decided the outcome of individual disputes. Gradually, however, kings got more power, and essentially two things happened. The first is the emergence of a distinct criminal justice system. The other is the growth in the power of kings and of their courts at the expense of other courts. This takes place particularly during the 11th and above all the 12th centuries. It's significantly helped by the church, which typically works alongside kings to do this, although the church has its own courts as well, as we'll see, and these are often in competition with kings' courts. But generally speaking, the church favours this growth of royal power during the High Middle Ages. Now, this growth of royal power, the initial beginnings, if you will, of the modern criminal justice system, has two sources. The first is that kings have a special jurisdiction over their own house. If you kill somebody while you're living in the king's house, in his palace, then you are tried in the king's court, and the king is the judge. What kings claim is that their entire kingdom is in some sense their house, and that the special jurisdiction, the dominion as it's called, that they have over their own household extends over the entire kingdom. And they gradually established this with the help of some pretty nifty arguments from the clergy in the course of the 12th century. The other source was that there was always a very small number of crimes, known as bootless crimes in Anglo-Saxon England, which you were not allowed to take compensation for. For these crimes, the only acceptable punishment was death or demembration. You either were killed or you had your hand chopped off. These incurred a penalty, as the Saxons used to say, of life and limb. What were these crimes? Basically, the list was extremely short. The first was treason, which meant killing the king or raising up rebellion against him, or killing your father, this was so-called petty treason, or killing someone in his own home, which counted as treason because one of the basic principles was that every man was a king in his own home. The second was rape. The third was arson. The fourth was murder. Now, you have to understand that murder meant a special kind of killing. Normal killing, if you will, was killing done publicly in front of witnesses, slaughter, as it was called, and this was settled for by compensation. A murder was a concealed killing, in which the perpetrator killed somebody at night time or when nobody else was present. What do these crimes have in common? The answer is that they all have an impact not just upon the immediate victim, but upon the wider community. This is obvious in the case of treason, which could lead to a civil war, or of arson, where in the absence of anything like fire service, you could burn down the entire village or town. In the case of rape and murder, the problem was that these crimes, because typically suspicion would fall upon parties who were not related to the, or unknown, or who were not certain to have committed the crime, it could lead to a blood feud. And so these were both crimes that tended to have a very high chance of leading to some kind of general breakdown of order. So consequently, for all of these crimes, the punishments were very severe and not allowed to be reduced or condoned or in any other way. And this gradually became the king's function, to enforce the law against these crimes. They became what were known as the placitae coronae, the pleas of the crown. And so gradually, kings become more and more powerful. They come to have a prescriptive right to try this certain category of crime, which they then constantly look to expand. And they also have a power of first instance in law because of the idea of the king's peace, the idea that in some sense the entire kingdom is their household. What the church did was to do away with ordeals by insisting that clergy could not take part in the process. And because the participation of the priest was vital for the ordeal to take place, it vanishes. This is finally got rid of by Pope Innocent III at the Lateran Council. The church replaced it with what they thought was a much more civilized and up-to-date system, which was torture, which gives you some idea of how progress can sometimes not be quite as good as it might do. What the church also does is to introduce the modern criminal procedure, which is known as the Ordo Judiciaris, which actually derives, in a way I don't have time to describe now, from a gloss upon the events of the first two chapters of the book of Genesis. And it's that which actually provides the basis for the criminal procedure that we're still familiar with today. However, there's a reaction against this. By the end of the 12th century, kings throughout Europe are facing severe pushback from their subjects. And also, there are many, many other kinds of courts, and the medieval king never managed to establish a monopoly. There are lots of other kinds of courts around there. There are church courts, which enforce canon law. This is the law of the church, but it has a wider range and remit than is the case today. Canon law includes, for example, almost anything involving an oath, all kinds of testaments, wills, lots of inheritance law, in other words, a whole range of contracts. There are borough courts held in self-governing cities. There are pie powder courts, courts of the law merchant, which are held at fairs, markets, and which involve almost any kind of transaction between merchants. There are feudal courts held by feudal lords. And then there are manorial and community courts, some held by lords, local lords, others held by peasants and local community peasants. This is particularly true in the Germanic lands, in places like Lüneburg, for example, or Brunswick, most notably. Now, how does criminal law work then in the later Middle Ages, after the system has settled down following the initial increase in royal power in the 12th century and the pushback in the later part of the 12th and the 13th century? One point to notice is that England is exceptional. It's exceptional in as much as there is only one system of law throughout the whole of the kingdom. This reflects the peculiar development and history of England, both before and after the Norman conquest. Elsewhere, in any one kingdom, there are typically literally hundreds of different law codes and legal systems. France has as many as 72 law codes and legal systems as late as the time of the French Revolution. In the Middle Ages, in the 14th or 15th century, the Kingdom of France, the territory of the French monarchy, has several hundred law codes. The situation in Germany, in the Holy Roman Empire, and Italy is even more complicated. And the same is also true in the Iberian Peninsula. So what do you actually have? Well, first of all, you have a lot of jurisdictions. In any kingdom, in any part of Europe, you have an enormous number of courts. In the Duchy of Gelderland alone, for example, in the Low Countries, you have over 200 different distinct courts, and that's just in one small area of land. in practice, these courts, even if they're supposed to be territorial courts, and not all of them are, they overlap. So what that means is, of course, that there's a lot of choice. If you are wanting to bring a law case against somebody, you don't have just one court that you can go to. You typically have lots and lots of courts where you could choose to actually initiate the case. If you have, for example, a dispute about a contract, you could choose to bring it in one of the King's courts, you could choose to bring it in a church court, you could choose to bring it in a borough court, a court of high powder, or even a local community court. Most of these courts, moreover, were run as profit-making enterprises. The people who owned the courts, heritable jurisdictions as they were often called, expected to make money out of them, and they charged fees for their services to reflect this. So what this means, of course, is that when you put these two things together, there's competition for clients. There are many, many different courts, each with their own enforcement system, and what these courts are doing all the time is looking for business. So the pursuer, the plaintiff, if you like, is in the fortunate position of being able to choose between a whole range of jurisdictions, all of whom are typically looking for as much business as they can get, and therefore are facing an incentive to provide as good and quick service as they can. I should tell you, by the way, that the average length of time during this period between first complaint and resolution of the case is typically maximally 6 months. This is remarkable when compared to the situation that we have today in any European state. 6 months actually, as I said, is the maximum. Normally, the resolution takes place within a matter of a month to 2 months. They do have relations with the royal courts and indeed with each other. One of the basic understandings is that courts will enforce each other's verdicts, and they also respect each other's verdicts. There's a very simple reason for this. A court which did not accept other people's verdicts would then be shunned by the rest of them, and that would in turn mean that its verdicts were worthless, so it would not attract any customers. So there was a very strong positive incentive to be part of a cooperative legal system in which, while you were competing for clients, you respected each other's decisions and enforced them. Bucking this was a way to lose all your clients and therefore basically to go out of business and not generate any income for the court owner and court holder. Royal courts would typically uphold the decisions of these other courts, but they were not in any sense the kind of default or ultimate court. This may have been the case in England and some of the Scandinavian monarchies, but on the rest of the continent this is not the case. The courts, in fact, of the king were simply one set of courts amongst many. It's also worth saying that royal courts competed amongst themselves. So in England you had 4 high courts which were all busily competing with each other. The King of France had a whole number of courts, many of which again were in a state of quite serious competition with each other. Another important point to make is that there is no stare decisis. What that means is that you don't have precedent in the way that you do in modern law, whether common law or civil law. What the courts do is to take account of the general history of how particular kinds of case have been decided, but they are not bound by previous decisions in the way that modern courts are. So you do not have the situation you have today where state-appointed, typically, judges create law which then binds their successors. Here you have private judges who take account of the decisions that earlier generations of judges have arrived at, but don't regard themselves as definitively bound by them. And the whole thing is driven still by private initiative. The way this works is that if you are the victim of a wrong, because the distinction between criminal and civil law is still extremely vague, what will happen is you will decide you want to go to a court, you will go to that court and you will apply for what's called a criminal letter, which is a document in which you basically describe the alleged offence in detail, giving details as time, place, and the like, and you also name the person you hold responsible for the wrong. The letter which you paid for is then served on the accused by an officer of the court, and it will contain at the end of it a summons calling them, telling them to appear before the court to answer the charges on a given date. Failure to answer this summons 3 times results in outlawry. And otherwise, you appear before the court, and the court will then hear your case. The court now will typically have professional judges or staff, although there is still a surprisingly large number of community courts surviving. Now, during the Renaissance, there's a further increase in royal power. A crucial aspect of this is the sudden rediscovery of Roman law. Roman law had been rediscovered in the 12th century, but it had been studied essentially as a kind of exemplar or model. It hadn't actually been used. But during the late 15th and 16th century, rulers throughout Europe, such as Charles V in Germany, for example, in 1525, had what's known as a reception of Roman law, where they remodel the legal system to make it conform to Roman practices and precedents. What this does in practice is to enormously increase the power of rulers and diminish the power of local self-governing communities. This is linked to what we call the military revolution, which is the change in the nature of warfare that takes place at this time, which enormously increases the power of states and monarchs. And so many would argue that by the early 17th century, you've got something like the modern state. However, you should not overemphasize this. As I said a moment ago, France still has 72 or 74, depending on how you count it, different legal systems in place by 1792. It's only with Napoleon that France acquires a single legal system. The situation in Germany is also very complicated. Scotland does not, for example, move towards a clearly modern legal system until the early part of the 18th century, and the same is true of places like Mecklenburg, for example, other large parts of Germany, notably Saxony. So although there are big changes and yet another shift in the direction of monopoly power, and an even further clearer distinction between civil and criminal law in the 15th, 16th centuries, again, it's not complete. The really big change takes place with the definitive appearance of the modern state in the period between 1750 and 1850. This is the period when the state of Weber actually comes into existence. And a crucial part of this is indeed the establishment of a monopoly of law enforcement by territorial states. You get the establishment of modern police forces so that private initiative is no longer a part of law enforcement. It is police and other agents of the state who will prosecute criminal offences in particular. This means that the distinction between criminal wrongs and other kinds of wrongs becomes much more sharp, much more clear, even than it had been already since the Renaissance. You also get the idea that if you are found guilty of a wrong, particularly a criminal wrong, one of the normal outcomes will be a penalty imposed by the state rather than compensation paid to the victim. Even in many civil cases, this comes to be the case, in nuisance cases, for example. And so you have the emergence of what we are now familiar with, the modern legal system with a state monopoly, with minimal scope for private action, with no real competition between courts and jurisdictions, much less any kind of private activity in this area. And this is what we take for granted. What we don't realize is how comparatively recent this historical development is in many ways, and how, although in one sense it's the culmination of a process that we can trace back to the 12th century, in another sense it's much more modern, and it's something that's only really been put through since the great reforming monarchies of the late Enlightenment despots and the other more liberal reforming movements of the 19th century. And also, it's worth saying, to go back to the very point I made at the start, that in fact there's been yet again a reaction against this, and that in commercial contract law in particular, but increasingly in other areas of civil law, there's been a significant movement again in the direction of private provision. Huge amounts of legal disputes are now settled or handled not by the courts of territorial states, but by arbitration associations, international arbitration bodies, professional bodies, and the like. And there is also, of course, an increasing move towards legal pluralism with the de facto existence of different legal systems within individual states, something which has alarmed and exasperated many people because of its association in particular with the spread of Islam in Europe. But in fact, it's something which is more than just that, and it's a more general phenomenon that's found throughout the world. So it may be that just as in the 12th century, the original rise of royal courts led to a reaction which produced a more hybrid system of the later Middle Ages, that we're undergoing another reaction now against the increasingly incompetent monopolistic state that has grown up since roughly the end of the 18th century. At that point I'll stop and I'll invite questions which Nick will pass on to me.
Thanks very much, Mr. Davies. I've already received a few. Professor, could you turn perhaps your volume a bit down?
Do you want to give me a few of them then?
Sorry?
Sorry, could you give me some of the questions then?
Oh, yes. The first question is from Mathieu. He asks, it's related to the beginning of your lecture. You mentioned a specific term which was called a boot, if I'm not mistaken.
A what? A boot, yes.
What was the correct spelling again?
It's a Saxon word.
Okay.
In the correct spelling, it's B-O-T with a circumflex over the O. It's often spelled boot, B-O-O-T. It means the same thing, though. It means compensation in general.
Okay. Next question from Chad. 2 of your essays are published in the Voluntary City, but why don't you pen down your own book on European history of private provision of law enforcement?
Well, the problem with writing a book about this is that it's one of those areas where the amount of the records are so scattered and the amount of information you have is so vast that to write a general European book would be very, very difficult. What we need is a lot more detailed local studies by historians of particular local institutions in, say, a province of France or part of the Holy Roman Empire or Italy. Only after we've got a lot of these local studies done will somebody be able to really provide the kind of synthesis. In one sense, you can do what I've just done now and give a kind of very broad overview or survey. There are other people who have done this. Professor Van Keinigem, for example, at the University of Ghent, had a couple of major works about this, published many years ago now. But it's very difficult to go beyond generalities with the level of research we have now. We need more local studies and specific studies of particular jurisdictions. There's no shortage of records, as is often the case with history. The problem is not lack of record, but too much of it. I mean, many of these courts, both royal and private, generate enormous amounts of record, which is scattered around all the archives in Europe. So there's a major project for somebody to undertake there.
Okay, next question from Imre. Couldn't the courts in the Middle Ages make their own cartel by excluding newcomers?
Well, you might have thought so. However, there's a number of ways in which that's difficult. The problem for a cartel like that is the one that, first of all, the one that always faces cartels, which is that it only works if it's in the interests of everyone to do this, and it's typically in the interests of at least one member of the cartel to break away from it. In particular, it's not clear that it's in the interests of kings or the church to uphold the cartel. Now, you might think that's surprising. Why should kings, of all people, want to create new courts? Well, the answer is because it often suits them to do this politically. So if you are a king and you are alarmed at the way in which some of your nominal subjects have extensive judicial power, one of the ways you can try to clip their wings is precisely by creating competitors to them. The church, the popes, effectively, have a similar kind of set of incentives. The other thing, by the way, which is also the case, is that in many cases, these courts arise spontaneously. They simply reflect the fact that certain people or institutions acquire power, and people then resort to them to settle disputes. What you constantly find, if you look through the records of the Middle Ages, is charters or grants by kings or popes to people, giving them the, quote, right, unquote, to hold a court. And this makes it look as though it's something which the king has graciously handed out. Sometimes it is, for the reasons I've just described. But what has often happened, which you can tell if you read between the lines or look behind that record to other records, is that the person in question, or the institution in question, has been gaily carrying on judicial work and holding a court and settling disputes for years. And that what the kings are doing is basically engage in a face-saving exercise by which they give the official seal of approval, literally, to these courts. But they're actually already in existence. They're simply recognizing a reality on the ground. What the court holder gains from this is the respectability of official approval by the king or the pope, which they are prepared to pay for typically. So what you usually find when documents like this are issued is that somebody has made a significant donation to the king's funds, and in return he's recognized what they're already doing and given it his seal of approval. But there's no real danger of a cartel for the reasons, both the inherent difficulty of creating one and because the key actors in this whole process actually have strong incentives not to allow a cartel to appear.
Next question comes from Jan. If someone was outlawed, could he easily move to a different city and live on as a free man?
Well, yes, you could. And if you went a sufficiently long distance away, then obviously you'd come to a place where nobody knew you, and so then you could live as a free man. A couple of things about that, though. The first is that the cost of doing this is high. I mean, the cost of migrating is always considerable. That's why people, have to have pretty strong reasons to migrate, because you go to a place where you maybe don't know the language, a place where nobody knows you, so you're going to find it very hard to find employment. It's not easy, to put it mildly. Moreover, the distance you have to travel is quite considerable. They have very effective and efficient ways of spreading news about who was or who was not an outlaw. It was partly by word of mouth, partly through using people who did travel long distances like merchants, monks, itinerant priests and the like to spread the word. So you could do this, but it wasn't an easy option and it had a high cost attached to it. From the point of view of the community that had imposed the banishment, they didn't give the proverbial monkeys one way or the other. The point from their point of view was that you had left them and you weren't going to cause them trouble anymore. There was one other thing which frequently happened, which was if people were outlawed, they would be marked in some way. A common practice was if you caught somebody and then they were outlawed, you would brand them. So you were immediately recognizable as somebody who was outside the law, regardless of whether or not you knew who they were. You'd simply be able to tell them the mark on them. That wasn't used that was quite a rare event though, but it was obviously the other fallback way of dealing with this.
Next question from Alex. Are there examples of how some courts continued beyond the Napoleonic era in more rural areas?
Yes, there are. There are quite a few cases where courts actually continue, this kind of system survives. The most notable is Mecklenburg. Mecklenburg, well, there's actually two principalities, but the big one. Mecklenburg is one of the constituent states of the Holy Roman Empire, and it's also one of the constituent states of the Kaiserreich, set up by Bismarck in 1872. As such, it's pretty much self-governing. It hands over its foreign policy to the new government in Berlin, but otherwise, and its defense policy, but otherwise it's independent. And the dynasty in Mecklenburg preserve almost perfectly the institutions and systems of the pre-18th century state. So it's a kind of curious survival, but quite a large one. I mean, Mecklenburg is not a small place. So the representative body, the Diet, and the court system there is pretty much as it was before the modern era began. All that, of course, is swept away in 1918 when the dynasty is overthrown along with all the other German princes. There are several other places in Germany where this survives. That's the most obvious and dramatic example.
Another question from Jan. What was the main function of kings in the Dark Ages, if not the provision of law?
leading the tribe in war is the straightforward answer. They were the war leaders, basically. And so, given the prevalence of war in that period, there was a fair amount of it going on. That was their big job. They did have other functions as well, some of which gradually disappear. One of the most important was that they had a sacral or priest-like function. There is a lot of argument about this, but a lot of historians argue that the kings of the Germanic peoples who moved into the Roman territory had a kind of sacral function which was tied to the fertility of the soil. So there was the idea that if the king was in good health, then you ought to have good harvests, whereas conversely, if the king was sick or injured, the land would become waste and infertile. You see this myth surviving in things like a lot of the Arthurian legends, the legend of the Fisher King who is wounded between the thighs and hence made impotent, and all the land he rules over is barren, the wasteland that Percival finds when he's on the quest for the Grail. And they do retain this. They have a kind of sacral function, and this is true even after conversion to Christianity. This is one of the reasons why the clergy who make Clovis, for example, the first king of the Franks, anoint him with oil, which is partly an allusion back to the Bible, to Samuel and the kings of Israel, but also it emphasizes this kind of mystical, sacral function of the king. Gradually this disappears because the church obviously does not want to share its spiritual powers with secular rulers, and so as the Middle Ages go on, particularly during the 12th century, the distinction between secular and ecclesiastical becomes much more pronounced. So back in the Dark Ages, kings' main job, other than settling disputes between important and powerful people and setting out what the basic law code was to fight wars. That was their job, essentially.
Okay, another interesting question. How come local community courts, everything you have described, have such a negative image in folklore and in fiction?
Well, I'm not sure they do have a negative image in folklore, actually. What they do have a negative image from is in the writing of subsequent historians, because they're seen as backward. And this is true of many classical liberal historians, because classical liberals have a very ambivalent attitude to the modern state. On the one hand, increasingly, they fear it because of its power. But when it first appears, it seems a liberating force, because what it does is to free people from the oppression, it's thought, of local overlords and also local communities. The modern state, it's thought, enables individuals to escape from the constraints of the local community. So when 19th century historians are writing the history of Europe, they tend to see the move towards more centralized royal power and the emergence of national legal systems under rulers like Philip Augustus or Henry II or Frederick Barbarossa and others as being part of the march of progress, as being part of the move towards a more modern and therefore more liberal kind of society. And so this shapes the way that people think about these community courts. It's only when you sort of take off that particular perspective that you maybe think that this move wasn't such a great thing, and that in many ways the system of community courts was highly flexible, highly effective, and much more libertarian, if you will. There is another element to this, though, which is that if you read things like Icelandic sagas, for example, it's true that in some of them, the thing, as it's called, the Supreme Court of Iceland, which is also in some sense the legislature, doesn't come out of it too well. But that's because what you're dealing with here is accounts of exceptional cases, cases where it was felt that something egregious has happened, somebody had been wrongfully outlawed, for example, and or a dispute had not been adequately handled, which is what happened in the case of Njál, one of the most famous sagas. But it's precisely because these are unusual that they become the subject of folklore or folk narrative. And so what you should not do is fall into the trap of thinking that the exceptional things which are captured in folklore and literature, precisely because they are exceptional, are in fact the typical or normal state of affairs. And that's a general point about historical evidence, by the way. It applies generally, not just in this case.
And another question on outlawing. How would outlawing people work today? Isn't it more difficult with larger and denser communities?
Well, I think I know how we would do it, and it would be different from the way it was done in the Dark Ages, but similar to the way it was done subsequently, because I don't know if any of you realize this, but the status of outlawry actually existed in most parts of Europe until the late 18th or early 19th century. But after about the 14th or 15th century, it no longer meant that basically you could be hunted down like a dog. What it meant was that your life was still protected, but you could no longer enter into legal contracts that were binding. In other words, you were outside the law in that sense. So during the Dark Ages, it meant, as I say, that you were literally completely outside the law, so your life was not protected by the law anymore. People could do anything they liked to you. They sometimes gave you a head start and then chased after you. It was almost like sport. That all stops really during the late Middle Ages and the Renaissance, when the new monarchs, people like Louis XI of France, the Tudors, Francis I of France, they stopped that. But the institution of outlawry still exists in the way that we could be, perfectly appropriate to use today. And that is, as I say, that it meant you no longer had the right to make contracts. People could break contracts with you at liberty because you no longer had an enforceable right. All your civil rights, if you like, were taken away from you. Now, you were still protected in terms of things like protected against theft, you were protected against assault and against threats to your life. But it was extremely inconvenient because it meant, as you can imagine, that you could no longer pay for anything except by cash. You could no longer engage in any kind of complicated commercial transactions. And that would be, we could certainly revive that sanction if we wanted to. And the penalties, as you can imagine, the cost of that, as you can imagine, is pretty severe.
I've received a few questions on similar systems in Asia and Middle East. I've received 3 actually. The gist is more or less, has the European evolution been radically different than other parts of the world, like the Middle East, like Asia?
No. There's actually, all the different parts of the world have very different patterns in this way. China has a completely different pattern from Europe, in which you have local community courts, but on top of these, from a very early period, from the 2nd century BC, in fact, you have the imperial courts, the magistracy established by the emperor, which coexists with local community courts in a way that's perhaps similar to the later Middle Ages, but where the imperial courts have much more power, because they're the ultimate arbiters and decision makers. And what tends to happen in China is that once any kind of legal case involves people of sufficient stature or sufficiently large amounts of money, it can only be handled by the imperial court. So the Chinese Empire has something like a state monopoly of serious dispute resolution from a much earlier period than any European state. In the Middle East, on the other hand, you have a system very like the one that I described until historically very recently. And in fact, of course, it survives today in Saudi Arabia and several other of the Middle Eastern states. You've all doubtless heard of the public executions that they have in Saudi Arabia, or public floggings and other corporal punishments for various kinds of crimes. What you may not know is that in cases like that, where somebody, for example, has been condemned to death for murder, and he's brought out into the public square, to have his head chopped off, they always have a pause for about half an hour before the sentence is actually carried out. That is to allow the family of the victim to agree to let the family of the perpetrator off in return for compensation. And so in many cases, the execution doesn't actually take place. The Saudi legal system is very, very similar to the kind of system that I described, and the same is true in quite a number of other countries in the Middle East. So the Middle East actually has, in many areas of it anyway, a legal system very similar to the one I described. What typically has happened is that overlaid on top of this is another legal system, which is either one imposed by the colonial powers, typically the British or the French, or which was imposed by the older imperial powers of the Middle East, the Ottomans or the Iranian Safavids. But underneath those legal systems, whether Ottoman or European, you find the older traditional customary legal system of the Arab world surviving and thriving. And that remains the case today in many parts of the world, like Saudi Arabia. It's actually still functioning. Africa again has a legal system historically in many parts of Africa which is very similar to the ones I've described. And again, if you go to places like Ghana, for example, you have the legal system set up by the British when it was a British colony. But in fact, most people do not use the state courts, which have descended from the British period. They would rather use the courts of, for example, the Ashantahene. If you're an Ashanti and you live near Kumasi, you're going to use the Ashantahene's courts, the courts of the local community and of the so-called tribal rulers, rather than go to the courts of the Ghanaian state, for the very simple reason that the Ashantahene's courts are a damn sight more efficient and low cost and less corrupt than the courts of the Ghanaian state. And that kind of phenomenon occurs right across Africa. So in some ways there are similarities between what happens in Europe, but in other ways the development in other parts of the world is quite different. So there's all kinds of variations, as you'd expect, of course.
Okay, and I've got one question left. Was the law always written down? That's the first question. And would oral law that's transmitted verbally, would it be less likely to lead to the growth of the power of the rulers because it is kept by the people?
The answer is that the law was not always written down. This is one of the problems we face as historians, which is that, of course, a huge amount of law is lost precisely because it was never committed to paper or parchment or whatever. However, there is a tendency, whenever you have a literate class within the community, to write things down, simply because, obviously, it does create a greater certainty than the oral memory. Having said that, you'd be surprised how often oral records are still used. Would an oral legal system be less susceptible? Not necessarily, because typically where you do have an oral legal system, you still do have a special class of people whose job is to remember what the law is. And if those people are co-opted by people with power or themselves become the people with power, which quite frequently happens, then the same process will happen. So I don't think there's anything particular about the medium by which law is transmitted through time that has a determining effect on whether or not the law will come to be captured or controlled or monopolized by people with political power.
Okay, thank you very much, Professor Davies, for giving the lecture and answering these questions. I hope it's been as interesting for everyone as it has been for me. Just a few concluding remarks on some of our future events. Our next regional conference, our last one, will be in Munich, and that will be on the 17th of November. Registration is still open, so you can still register until the 11th of November, that's this Sunday, and it's only for German-speaking students. And of course, I should mention that our European Students for Liberty Conference, where Professor Davies will be speaking as well, is also having a deadline coming up. On the 15th of November, the fees go up for students and non-students. So do make sure to register early. Have a look on our website. All the information is on there, and we will be posting more information on accommodation, etc. in the coming days. Tomorrow we will have our another Italian webinar, so check out our website and our Facebook page for more information on that. And in 2 weeks' time, on the 20th of November, the next ESFL webinar will be held, and that will be about how private schools improve the conditions of the poor, with examples from Africa and Asia. And we will be joined then by Pauline Dixon, who is an expert on that matter. Then I will conclude with thanking every one of you for signing in tonight, and I hope to hear you all soon. Good night, everyone.